At least seasoned litigators know that neither life nor court is quite like what we see in movies. That ultimately it's not about the truth in court, but only what you can prove in the courtroom, leading to a flurry of cleverly designed tactics reasonably calculated to either include or exclude evidence from the court record. And most importantly, if you are truly a seasoned litigator, worthy of that rather handsome sum offered by clients in your retainer, never ask a question in court unless you already are clearly certain of the answer. Litigation is not a guessing game or whodunit, and no litigator wants to wake up surprised in court. No tolerance there for any involving signs or October surprises. And if you ask the state attorney general in the show me state, he will be more than happy to show you the links to inform you that Missouri Attorney General Andrew Bailey secured a historic $24 billion judgment against the Chinese Communist Party for unleashing the COVID-19 pandemic, 6 times more than the previous largest judgment in Missouri history. That sounds too good to be quite true. Well, according to the New York Times, often described as a reliable source for news content, under a headline banner that the most in a news story that statistically most people actually read, a U.S. judge had found China liable for COVID missteps. And they opened this headline news story with the victorious announcement that a federal judge in Missouri had found the Chinese government responsible for covering up the start of the COVID-19 pandemic, covering up and hoarding protective equipment in a ruling on Friday. They explained the lawsuit filed by the Missouri State Attorney General's office in April 2020, the month right after the pandemic declaration, during the early months of the pandemic, accused the Chinese government of withholding information about the existence and spread of the virus, and then of cutting off the supply of personal protective equipment, or PPE, from the rest of the world. However, Chinese officials said Friday that they did not accept the judge's decision. Nonetheless, this is a landmark victory for Missouri and the United States in the fight to hold China accountable for unleashing COVID-19 on the world, said Attorney General Bailey. The most interesting, however, for learned court watchers, a bit more savvy and familiar with court and viewers of court dramas on television and in movie theaters, had appeared in the pages of the Washington Examiner, who credit themselves as investigative journalists. And they had reported unequivocally the summary judgment from Judge Stephen Limbaugh of the U.S. District Court for the Eastern District of Missouri found that China intentionally engaged in a campaign to suppress information about the existence, scope, and then human-to-human transmissibility of COVID-19. How dreadful. However, for those unfamiliar with legal terms of art and courtroom legalese, when a court, acting as what is described as a trier of fact, often the function of a jury, has published a finding of fact, any legal conclusions based upon that finding of fact may be overturned later or reversed if the verdict wholly contradicts the evidence in what is often described as a judgment non obstante veredicto, or judgment NOV. It is often said in court that in due diligence, a person cannot claim ignorance when facts call for investigation, because in such a case, the person has a duty of inquiry. And many people had claimed that in order for us to determine the origins, we would have to get into the labs in China, but had been thwarted by Chinese obfuscation. But now in the courtroom, after a judgment, apparently a sudden re-judgment according to this account, they have determined They have found that this is a fact. However, as any first-year law student can probably recite blindfolded from rote memory, on the U.S. v. U.S. Gypsum Company, decided by the Supreme Court in 1948, a finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with the definite and firm conviction that a mistake has been committed. Weighed against this bright line rule standard, could we credibly, persuasively say it was not clearly erroneous to report that a federal court had recently found that China had intentionally engaged in campaigns to suppress information about the existence, scope, and then human-to-human transmissibility of COVID-19? Could evidence possibly refute their claim that it revealed that China was made aware of the human-to-human transmission of the virus as early as September 2019? According to Zhenjing Li, 2005, that coronaviruses could not be passaged over to humans without considerable effort. Or that the Chinese Communist Party publicly had denied the existence of the COVID-19 virus until December 31st, 2019, and denied its ability to transmit between humans until January 2020. All of this information determined as fact in a court in which there were no Chinese witnesses. Probably beyond question, evidence submitted by Missouri, however, demonstrates Missouri's claim that China repeatedly and knowingly misrepresented the existence and human-to-human transmission of the virus for months prior to these commissions. It is the job of one party in court to present their case with an opportunity for rebuttal. However, even the official website or state attorney general in the Show Me state of Missouri admits or concedes that in fact China had refused to even show up to the court. And in that court, that is not even described as a summary judgment, not even in the order that was written. Brief though it may have been, but not quite a summary judgment properly termed. In a summary judgment in federal courts, according to Federal Rule of Civil Procedure 56, the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. Alternatively, under Federal Rule of Civil Procedure 55, we are bound by rules and rule of law when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, and that failure is shown by affidavit or otherwise, the clerk must enter the party's default. A default judgment. Very different from a summary judgment. So apparently the Attorney General had submitted a sworn affidavit in a case that had been commenced in April 2020, not long after the pandemic declaration, when the Beijing government had refused to appear for 5 years, and only after a virus had been attributed to the deaths of more people than had been killed by Hitler in the Holocaust in half the time, and over 1.2 million of those Americans in that death toll. Now, according to this press release in the Show Me state from the Attorney General, that doesn't mean they get away with causing untold suffering and economic devastation. We intend to collect every penny by seizing Chinese-owned assets, including Missouri farmland, and somebody voted for him in the Show Me state. Yet, under Federal Rule of Civil Procedure 11, applicable even in the Show Me state, by presenting to the court a pleading, an attorney certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Yet further he certifies that to the best of his knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. In April 2020, when the Attorney General in the Show Me state had commenced his litigation against the Beijing government, was he not aware that on March 27, 2020, the HHS Secretary had determined, as published in the Federal Register, like a law, that a public health emergency or a significant potential for a public health emergency that affects or has significant potential to affect national security or the health and security of United States citizens living abroad, and that involves a CBRN agent or agents, or disease or condition that may be attributable to such agent or agents. The traditional rule dictates that ignorance of the law is no excuse. Knowledge that the conduct is unlawful is all that is required under the law. Written messages are not communicated unless they are read, and reading requires an affirmative act under the law. And the term CBRN stands for chemical, biological, radiological, and nuclear, and relates to specific hazards that may be encountered during an incident. And the term CBRN is generally reserved for the deliberate release of hazardous material, not escaped material, such as in a terrorist attack, whereas the term hazmat is used for accidental release or escape or exposure to toxic industrial material. Not the Chinese, but the World Health Organization that had declared the pandemic had dispatched the manpower equivalent of 2 military brigades of epidemiologists to China in February 2020 to examine 19 times more cases than had yet been reported in the entire United States by mid-March 2020, when this economic devastation of closing down began. And not the Chinese, but the WHO had determined that a person had a less than 5% chance of catching COVID-19, about your chance of getting into Harvard if you feel yourself competitive enough to apply. 12 times too low to be described as a highly contagious disease under the science, even capable of setting off a super spreader event under the science. And in a 40-page report apparently never read by the Attorney General in the Show Me state, they had concluded in a plain and simple statement, it is not clear whether this correlates with the presence of an infectious virus. How do you go to court without reading a science report? Yet, under the federal rule of Civil Procedure 11, applicable even in the Show Me state, by presenting to the court a pleading, an attorney certifies that to the best of that person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigating or discovery. What evidence had been presented before this default judgment or considered to reject the WHO investigation of the outbreak in China and the determination by the HHS Secretary in March 2020 to issue an emergency use declaration? It served as the basis for rapidly developing not vaccines but countermeasures. Perhaps somebody in the Show Me state will have to show some evidence to the Chinese if they attempt to collect $24 billion by seizing property, because reckless conduct like that could start a war. And you look like an intelligent person. This message was approved by Major Mike Webb. Honest.